Adoption annulment statutes have been around for more than a century. This is a statute from 1917 in Minnesota, which was considered a groundbreaking in modern adoption law at the time. This law, which became fairly typical across the country over the decades, was on the books until the early 1960s. And as you can see, there were limitations on annulment back then, as always has been the case, including a time limit on the availability to seek annulment. But as you can see, annulments are almost always focused on the adoptive parents, particularly parents who believe they got a raw deal in the transaction. Here in 1917 was a list of some of the common raw deals: an undisclosed defect in the adopted person. If within 5 years the adopted child develops epilepsy, insanity, venereal disease, or feeble-mindedness, which was a broad term that grew out of the eugenics movement, then the adoptive parents could annul the adoption. It also had to be a condition they didn't know about and didn't discover until after the adoption. But if they could prove it, the court would annul the adoption and give the child back to the state. These statutes still exist. In California, for instance, current law allows annulment if the adoptive parent discovers evidence of an undisclosed developmental disability or mental illness. Kentucky goes one step further and still enshrines an element of eugenics in its law today. Enacted in 1950, Kentucky's annulment statute relates solely to ethnicity and race. That is, if an adoptive parent discovers definite traits of ethnological ancestry different from those of the adoptive parents, and they had no knowledge of it before the adoption, then the court may enter a decree of annulment. That is, if you are a white adoptive parent, and your child is perceived later as black, an adoptee of color, or an indigenous child, you have a legal right to annul that adoption and give the kid back. These provisions were not limited to laws either. Many agencies had their own return policies, some extremely broad. This is one from the Catholic Home Bureau in New York. It's from one of my friends who is a New York adoptee rights activist. The Catholic Home Bureau had a contractual policy that stated, "The family is at liberty to return the child to the Catholic Home Bureau for any reason the family decides that it ought not to keep the child." Such a return policy was unheard of in the 1960s for a car or any other marketable item, except for adopted people. So that's a very brief overview. Of course, today, even though annulment laws are more strict and often have shorter time limits, they still exist in some form. But importantly, an underground system of annulment is thriving. That is, rehoming, or what is technically called unregulated custody transfers, is a way to secure extrajudicial annulments, especially for adoptive parents who feel, like adoptive parents 100 years ago, that they got a raw deal. Rehoming is legal in many states. It has created a secondary adoption market, and it happens in anywhere from 3 to 10% of all adoptions, though the stats likely underrepresent the reality. Importantly, though, rehoming happens at a much higher and alarming rate for intercountry adoptees, black adoptees, adoptees of color, and older and disabled adoptees. That is, the ghost of eugenics still follows us. So this is my question, which I'll explore in more detail in part 2. If there's always been a formal or informal right of return policy for adoptive parents, with remedies to fix what they believe was a raw deal, what about an adult adoptee who got a raw deal? Should there be a right to annul your own adoption? After all, at every chance, courts remind us that the best interest of the adoptee is the paramount consideration in all adoptions. So what if that best interest, your best interest, is to annul the adoption? I'll talk about that next, including what such a right to annul could look like.